Welcome. It's the appointed time and we have a quorum. I call the meeting to order. Let's invite the administration to come into the conference room first. If I may remind members, if you have any interest in relation to this topic of discussion today, please declare it. We have the Secretary for Home and Youth Affairs here, representatives from the Inland Revenue Department and Department of Justice here. Welcome, Secretary Mack and your team. I'd like members to note that the administration has submitted a response in relation to items raised at the last meeting on the 11th of July and the letter sent to the administration by the legal advisor on the 10th of July. They are CB bracket 3 1160/2025 bracket 01 and bracket 04. Before the deadline for submission of public representations on the bill, the Secretariat received a total of 9 representations. The administration have submitted a consolidated response to the submissions received by the Bills Committee. The paper is CB bracket 3 1160/2025 bracket 03. All of the documents were sent to members. As there's nothing special in the administration's response, they are for your perusal only. To facilitate the scrutiny of the bill, I think that we should address the legal advisor's questions when we come to the relevant clauses in the clause-by-clause scrutiny. Now we can go directly into the examination. Please refer to the blue pill and the marked up copy. It is CB bracket 3 1093/2025 bracket 01. Now I'd like to ask the administration to lead us in the clause-by-clause examination. Legal advisor, if you have any questions, please raise it. Mr. Yim will take us through the clause-by-clause examination. Mr. Henry Yim, Principal Assistant Secretary. Betting Duty Amendment 2025. Amend the Betting Duty Ordinance and subsidiary legislation to empower the Secretary for Home and Youth Affairs to authorize betting and basketball matches. Please speak into the microphone. Well, the Betting Duty Amendment Bill 2025 seeks to amend the Betting Duty Ordinance and subsidiary legislation to empower the Secretary for Home and Youth Affairs to authorize betting on basketball matches. The bill also seeks to repeal any obsolete provisions. There are 24 clauses to the bill. The long title has been set out on C3669 of the Blue Bill. Amend the Betting Duty Ordinance and subsidiary legislation to empower the Secretary for Home and Youth Affairs to authorize betting on basketball matches, to charge a duty on the net stake receipts derived from the conduct of authorized betting on basketball matches, to allow companies that conduct authorized betting on basketball matches to bet on basketball matches for the purpose of hedging, to repeal obsolete provisions on guaranteed amount for non-local horse races, and to make related and textual amendments. We base the scope of this bill on the football betting regime. We also like to take this opportunity to repeal obsolete and out-of-date provisions so that it can come into alignment with the prevailing standards of drafting. These may not be directly related to basketball betting. We like to update the relevant provisions. In the following, I will go into Part 1 of the bill. There are 2 clauses to it. Please refer to C3669 of the Blue Bill. Clause 1. This ordinance may be cited as the Betting Duty Amendment Ordinance 2025. Clause 2. Please refer to C3671 of the Blue Bill. Enactment amended. The enactment specified in parts 2, 3, and 4 are amended as set out in those parts. Now we come to Clause 3. Please refer to C3673 of the Blue Bill and page 1 of the marked up copy. Dr. Zhang. Chairman, I have a question relating to Clause 3. We're going to repeal and betting on football matches by betting on football matches and betting on basketball matches. Why is that? Mr. Yim. In the Chinese version, in the original provisions, there is not such a word of betting. Why did we add it to it? After the amendment, the provisions will become betting on football matches and betting on basketball matches. The word betting already exists in the original provision. We're just changing the order of the word betting in Chinese. Any other questions? If not, please proceed. Clause 4, please refer to C3673 of the Blue Bill and page 2 of the marked up copy to page 5. Clause 4, amend Section 1A of the Betting Duty Ordinance. We're going to introduce new definitions to implement the basketball betting regime. The first amendment is a textual amendment. Subclause 2 and 3 is about definition of authorized betting activity and charging period. Clauses 4 to 8 are textual amendments. Clause 9, we're going to repeal obsolete references. Clause 10, we're going to introduce the definition of basketball betting conductor, which means a company authorized under Section 6WH to conduct betting on basketball matches. Any questions? Mr. Chan Shu-hong. Chairman, I'd like the administration to explain more about why they repeal the definition of charging period. I know that they will not be applicable anymore, but I hope that the administration will elaborate further. Thank you. The member just now talked about guarantee period, guaranteed amount, so on and so forth, because the administration amended the betting duty ordinance in 2013. The charging amount was changed from a progressive rate of 72.5 to 75% in order to make sure that during the initial phase of the implementation of the new duty regime, the administration asked the Jockey Club to guarantee that the 3 years starting from the 1st of September 2013, they will have to pay a guaranteed amount. Because the period has been expired since 2016, that's why we take this opportunity to repeal the obsolete and out-of-date provisions. Thank you. Understood. Please carry on. Thank you, Chairman. Now we've come to clauses 5 and 6. These are technical amendments to expand the scope of the provisions. Now I'd like to talk about clause 5. Please refer to C3679 of the Blue Bill and page 6 to page 7 of the marked up copy. Clause 5 amends Part 3 heading. The current heading is betting on horse races and football matches and lotteries. We're going to add the words football matches and basketball matches so that part 3 will also cover basketball matches. Ms. Yong Hwa-yan. Why do we use so many ands instead of commas? Why not horse races, comma, football matches, and basketball matches? Who will take the question? Mr. Ho or Ms. Wong? Thank you. Ms. Ho? Both ways of drafting work. Because horse races are not matches, and football matches and basketball matches are both matches, that's why we link them up with the word and to show that they are of the same nature. And the lotteries will be the third type of activity. That's why we use the comma to separate all these 3 types of activities. This is the title to a part of the bill. It will not affect the operation of it. Any follow-up questions? Mr. Yim, please proceed. Thank you. Now we've come to clause 6 of the bill. Please refer to page 7 of the marked up copy. We amend section 6E under this clause. The original provisions says that the function of the Commission is to advise the Secretary on matters provided for or otherwise relating to this part. In order for the Commission to advise the Secretary on matters relating to also basketball matches, we are going to amend the provisions by including the words basketball matches. We are also amending the word government to SAR government. I will go into it in detail later on. Any questions? No? Please proceed. Thank you. Clause 7. Please refer to page 8 of the marked up copy. Clause 7 amends section 6GA relating to Division 2A, definition of horse race betting duty. This is a technical amendment. We're going to repeal it because it relates to overseas horse race betting. Now we come to clause 8. Please refer to page 11 of the marked up copy. Clause 8 amends section 6GB. To amend the provisions on displayed notices under the authorization of betting on horse races. 6I and 6X also requires the conductor of horse races, lotteries, and football matches to display and keep displayed notices in premises where the company accepts bets or through which the company accepts bets, notices or warnings against irresponsible gambling. In light of the technological advancement, people no longer just have to go to the websites of the Hong Kong Jockey Club or the betting branches to place their bets. To promote responsible gambling, the bill proposes to extend the requirements to also mobile application to cover all betting channels to make sure that the relevant information will reach all bettors to minimize the impact of irresponsible betting or gambling in the community. The same references will exist and relevant clauses in relation to football betting, basketball betting, and lotteries.
Members, questions? Please continue. And we're now on clause 9. Please refer to 0013 to 0014 of the markup copy. Here we're going to repeal the 6GEA and 6GGA. They're about the guarantee period and the betting duties arising from such non-local races. It's a part of what I've just said in repealing some more provisions. Clause 10, please refer to 0016 to 0018 of the markup copy. Clause 10 amends Section 6GI to repeal the subsections 3 and 4, and that is the provisional payments requirements, which are now obsolete. Please continue. Clause 11 now. Please refer to 0020 of the markup copy. Clause 11 amends the Section 6I concerning authorization of betting on football matches. As I've just said, we will require that the relevant warning notices to be published on the Jockey Club's website and mobile, and additionally mobile applications. And now we have another 4 provisions regarding 6K, Section 6K, 6L, 6P, and 6 12, section clause 12. Please refer to 0021 of the markup copy. It's about 6K, and that is the calculation of net stick receipt. In the conduct of authorized betting on football matches, the net stick receipts will be calculated in a certain way. Clause 12 introduce some textual amendments without affecting the substantive meaning. Please continue. Clause 13. Please refer to 0023 of the markup copy. It's about Section 6L to be amended. Adjustment to net sticks receipt. And adjustments are to be made in certain way. Section, of course, 13, we're going to repeal Section 4 to be renumbered subsection 5, so that it would conform with current drafting style. There's no change to the meaning, substantive meaning. All right, textual in nature. Clause 14, please refer to 0024 of the markup copy, Section 6P to be amended. That is in relation to assessment of net stick receipt. The controller of stamp duty will have to assess to assess the net stick receipt and collect the duty. And he can also collect any amounts in arrears, or the controller may also repay excessive amounts. So this section would renumber Section 6P3 as a 6P3 capital A to clarify the meaning, and also there are some consequential amendments to 6T without changing the substantive meaning. Questions? No? Please continue. Clause 15. Clause 15 is in relation to the addition of Division 3B, betting on basketball matches in Part 3 and Division 3. It would amend 6WG to 6WG section, newly enacted 6WG. Please refer to page 0025, the markup copy. 6WG is under Division 3B, betting on basketball matches. It set out the relevant interpretation of the terms in Division 3B. notice in relation to notice of assessment, notice of additional assessment, provisional payment, and last charging period, and basketball betting licenses and duty, etc. Please continue. Ms. Carmen Can, I have to declare I'm a member of the Hong Kong Jockey Club. The legal advisor has asked questions about certain certain terms such as basketball and whether this mobile application should be defined. The secretary should provide, or I think that the secretary has already provided an answer. But what about elaborating on the need to have a definition of basketball here? Do we need a definition of basketball, Mr. Yim, or Deputy Secretary? Mr. Yim, thank you for your question, Ms. Can. As we have explained to the legal advisor in a letter, it said that we have a definition on football, but we propose no definition for basketball. In different regions and countries, they may use the same term football to denote different sports such as American football, etc. But for basketball, we see that in different regions that they are all referring to the same sport. So we don't think we need a definition on basketball, because basketball may just mean the same sport, although there may be different rules. So you mean the term is clear enough in itself? And the 3x3 basketball is outside this definition. If a team has a different number of players, are you going to have an open-ended definition about the size of the team? Under the regulation, after the enactment of the law, we will have to take it up with the conductor, that is the Hong Kong Jockey Club. We have no preconceived ideas about the kind of matches that can be involved. Thank you. Next, the new section 6WH. Please refer to the markup copy, page 025 to 027. The new section 6WH. Mr. Chan Xiu-Hong, are your questions related to this section or the previous one on 6WH bracket 1? Okay. This is about authorization of betting on basketball matches. The secretary may authorize a company by issuing a license to conduct betting on the result of betting. Is 6GB is for horse racing, 6I for football matches, for 6XH on lotteries. That is to say, this new section is based on the current regulatory system for other betting activities. Mr. Chan Xiu-Hong. Thank you, Chairman. Concerning the text, well, it's easy to read. I have a question about the drafting style. You are modeling this on I, that is football matches. The meaning looks similar to me, although you use different words. Why don't you just copy 6I? The original XI is not as easy to read as 6WH. For example, the secretary must be satisfied that those parties are fit and proper parties. Do you think? Well, if you think this is a better drafting, why don't you just also amend I on football matches? Mr. Ho? Or Miss Ho? Thank you, Mr. Chan Xiu-Hong. Well, I think you have been very careful in reading this. This is based on 6I, although we use a different drafting style. The regulation on betting on football matches was introduced in 2003. At that time, the drafting style was rather old-fashioned. In 2012, the Law Drafting Division of the DOJ introduced or gazetted or published a new drafting policy. In short, we would like to use easy to read drafting styles. That's why it is different from the division on football matches. And then the question is, why don't we also amend the provision of the subsection on football matches? I think the legal advisor has raised a similar point in her letter to the administration, and the administration has responded that this particular bill is for the introduction of authorized betting on the football matches and the establishment of a regulatory framework. Therefore, it's not the legislative intent to introduce this bill to improve the drafting of the betting duty ordinance. So we're not going to have a wholesale amendments on the drafting aspect. Our instructions, the instructions we have received, is that this bill is not intended to achieve this. That's why we don't have wholesale amendments to other provisions. We have other activities covered by the same ordinance, such as horse racing and lotteries. And to do this will involve a very heavy workload. Well, the new drafting, WH, is smoother, it's easier to read. But I understand this is not the right opportunity to introduce amendments to all those who previously enacted provisions to improve the fluency. But for 6WH bracket 4, it's based on the new drafting style. And then we have A, B, C, D under bracket 4. The term the company is repeated in those paragraphs. But of course, it would be more succinct if we have the company in the previous sentence. So is it the policy now to repeat the term the company instead of having a subsuming term in the previous paragraph? Yes, your understanding is correct. For A to G, 7 paragraphs. You can see that in the blue bill, it takes up a whole page. C3688 for the Chinese version. If we place the term the company as the lead in, it will not really be difficult for the reader to understand what's involved. Here we're not just concerned about the number of words. We are concerned about how easy it is to read.
Mr. Kenneth Falk, I have to declare interest. I am a voting member of the Jockey Club. I would like to ask about 6A, the Chinese and English version. Contains a warning of a seriousness of excessive gambling. According to my understanding, excessive is not equivalent to addiction. You use the word addiction in the Chinese version. I think that you should replace the English word excessive with the word addicted or obsessive. Ms. Ho? Thank you, Chairman. I thank Mr. Falk for the question. We've made reference to the relevant provision 6I on football matches. We can refer to section 6I bracket 6A on containing warning of the seriousness of the problems caused by excessive gambling. The English rendition is exactly the same. We also use the word excessive gambling there. As to whether we can replace it with other wordings, we believe that those are just synonyms which carry the same meaning. So given the context of this bill, well, you may also refer to subparagraph B. It says provide information on the services and facilities available in Hong Kong to problem gamblers and pathological gamblers. We believe that the understanding is clear enough as to the references of excessive problem or pathological gambling or gamblers. We think that the meaning carried by the Chinese and English rendition is exactly the same. I just like to have the provisions become more clear. I know very well about the legislative intent. I think that this is just a suggestion for the DOJ, so that when they draft laws in the future, they will pick some better words. Thank you. Mr. Yim. Thank you. Now I will go into 6WI and to 6WS. They're about basketball betting duty, calculation of net stake receipts, adjustment to net stake receipts, so on and so forth. Provisions, no payment, assessment of net stake receipts, and the holding of provisional payment. First, on 6WI, please refer to page 27 of the marked up copy. 6WI basketball betting duty. It says that a duty is charged at the rate of 50% on the net stake receipts derived from the conduct of authorized betting on basketball matches by a basketball betting conductor for each charging period. This is based on 6J on betting duty that has to be paid by football betting conductor. Ms. Carmen Khan. Thank you. I have a question in relation to 6WI bracket 3, which says that the LegCo may by resolution amend the rate of duty. That is 50%. The administration just now said that they base this provision on the relevant clauses for football betting. If we are to amend the rate of duty, what procedures do we have to go through? Second, in the administration replies to the submissions from the public, Well, some members of the public talked about the financial challenges faced by the government, but the administration said that we should not consider the fiscal position of the government when they are determining the rate of duty on basketball betting duty. We should not raise it just because of the fiscal deficit that we're facing. I think that the administration has to clarify the legislative intent of this bill. I'd like to know about the process that we have to go through if we are to amend the rate of duty. Ms. Wong? Rather Mr. Wong or Ms. Ho? If we are to amend the rate of duty, what procedures do we have to go through? I will ask the DOJ to talk about the procedures and then I will elaborate. Ms. Ho, Government Counsel, please. Thank you. Well, it may be amended by resolution of the LegCo. Is a positive vetting subsidiary legislation. That is, if the government thinks that there is a need to amend the rate of duty, they may formulate a piece of subsidiary legislation by motion submitted to the Legislative Council, and then the LegCo may, by resolution, decide whether or not to approve the relevant amendment. The LegCo itself may, by resolution, amend the rate of duty on their own volition. Regarding regulations and rules, please refer to the Rules of Procedure, Rule 31. Thank you, Ms. Mack. Thank you, Chairman. I thank Ms. Khan for the question. If we are to amend the rate of duty, we will follow Rule 31 of the Rules of Procedure. As mentioned, we decide on the rate of 50%. After having conducted the research, we want to offer a restricted and regulated ways for people to place bets on basketball matches because we want to combat illegal basketball gambling. Tax revenue is not one of our considerations before we decide on the rate of duty. The goals shared by the government and the members is to combat illegal basketball gambling. We take enforcement action, conduct publicity campaigns, and education, as well as to table this bill into the LegCo in order to provide a legal means for basketball betting. So what we're doing is to combat illegal basketball gambling. We're not here trying to raise tax revenue of the government. Mr. Yim. Thank you. 6WJ and 6WK sets out the calculation of net stake receipts and adjustments to net stake receipts. First, on 6WJ, please refer to page 28 to page 29 of the marked up copy. 6WJ says that, subject to any adjustment made under Section 6WK, the amount of the net stake received derived from the conduct of authorized on basketball matches by a conductor is calculated by using a formula set out in the blue bill. Mr. Chan Shi-hong. Thank you. I have a question regarding 6WJ. We have been regulating football betting for quite some time. And because the operation is quite smooth, that's why we are copying the provisions. But there's one word in 6WJ that I noticed. There is a word after the capital letter A. The formula is set out in subclause 1, A minus B. I've made reference to 6K on football matches. There is not a word after 6K bracket 1 bracket A bracket B capital letter A bracket A. Why do you include the word "and" here but not in section 6K for football betting? There is no "and" under 6K. Ms. Ho, Government Counsel, please. Thank you. Under section 6K, even without the word "and," if we read the entire paragraph, there will not be any misunderstanding. In the old ways of drafting, we sometimes do not use the word "and" to connect different sentences. However, what A and B represent are very clear. We add this word "and" under 6WJ just to further clarify the connection. With or without "and" will not affect the enforcement of the laws. We've made reference to other ordinances where formulas are set out. And in these days, we tend to use the connectives. Mr. Yim. Thank you. Now we've come to 6WK. Please refer to page 29 to page 31 of the marked up copy. For the purposes of section 6WJ, which we've just gone through, that is the formula for the calculation of net stake receipts. We've made reference to 6K and 6L on the amount of the net stake receipts derived from the conduct of authorized betting on basketball matches by a conductor. The calculation is the same. 6WL, please refer to page 31 of the marked up copy to 33. 6WL is about the definition of charging period. It says that charging period in relation to a basketball betting conductor means a period within which the basketball betting license issued to conductors is enforced, being a period that begins on the day on which the license comes into operation and ends on the earlier of the next following 31st of March, the date on which the license is terminated, or any subsequent period that begins on the 1st of April that ends on the earlier of the next following 31st March, the date on which the license is terminated. We've made reference to section 6M. Any questions? No, please proceed. Now on 6WM. Please refer to page 33 to page 34 of the marked up copy. 6WM, basketball betting conductors must make provisional payments. It says that the basketball betting conductor must make a provisional payment to the collector within 15 days after each accounting day in a charging period. They also have to submit a calculation sheet in the specified form showing how the amount is being paid is arrived at. The provisional payments made by a conductor will be used toward settlement of the basketball betting duty payable for the conductor for that charging period. We have made reference to 6N on the provisional payments to be made by football betting conductors. Legal advisor has a question.
With regard to bracket 5, members may have noticed that a basket betting conducted would contravene subsection 1, would commit an offense if there's no reasonable excuse. So there's a statutory defense of reasonable excuse. The legal department of the council has or to ask the question whether there is only an evidential burden here. Those who have committed the offense is only required to introduce some evidence to raise a reasonable doubt. I would like the administration to clarify whether this is the legislative intent, and also why there is no mention of this being an evidential burden. Because there are other provisions in other laws that when one wants to invoke such a defense, the party concerned would only be required to introduce some evidence for it. It can be found in the Import and Export Ordinance 2025. Mr. Leung. Thank you, Chairman, and thank you, Legal Advisor, for your questions. For 6WM bracket 5, it will introduce a new offense, which is regulatory in nature. And the penalty is light. And that's why we make it a provision that no mens rea is required, but the conductor can raise reasonable excuse as a defense. The intent here is that the conductor should be given some safeguard, and that no prosecution will be initiated unless the Secretary is satisfied that the conductor has not complied with certain elements. And that is, he has not complied with this provision, and secondly, there's no reasonable excuse on the part of the conductor. So when the conductor raised this as defense of reasonable excuse, he has only the evidential burden to do this, and the Secretary will have to introduce evidence to rebut this defense so as to do away with any reasonable doubt. Mr. Chan Siu-Hong, I need to understand the meaning of charging period, because I have limited knowledge about the term charging period. I think it means any financial year or accounting period up to the 31st of March, or if prior to that it has come to an end, and that is only the need to make one payment. So we have one charging period and one payment date. Or is it that a number of payments will have to be made within the same charging period? Mr. Leung, thank you for your question. If we look at 6WM, Section 6WM, bracket 1, a basketball betting conductor must make a provisional payment to the collector within 15 days after each accounting day in the charging period. And in bracket 6, in this section, accounting day means any day within a charging period. That is the last day of a month. In other words, the collector has to make a payment every month. So it's a payment per month. What in the provisions for football betting on football matches is every month or certain month, the last day of a certain month. Is it the same? Well, the effect is the same. It means the same thing. Mr. Carmen Can, I think you haven't answered all the questions raised by our legal advisor. They have raised questions about why you don't spell it out, just like the Imports and Exports Ordinance. Of course, we can ascertain the need to have a mens rea, etc. in the commission of the offense, or whether there's a need to prove beyond reasonable doubt by the prosecution. Perhaps the DOJ can help us here. Secondly, this is a new offense. Is it new here, or is it going to apply to football matches as well? Betting on football matches as well? Mr. Leung, why don't you spell it out? Mr. Leung. For this new offense, we have make reference to the provisions on horse racing and football matches, betting on football matches. So it's similar to the offense concerning horse racing and betting on football matches. So the drafting is similar or identical. As I've said, this is a regulatory offense and a straightforward one. When it comes to enforcement, there has not been any controversy concerning the regulation of horse racing and betting on football matches. So we just want to introduce this to maintain consistency. So this is already applied to betting on football matches, and there's no need to introduce the same offense for betting on football matches. Please repeat this. What's the provision so that we can read it? It's in 6N. Mr. Yim, please continue. Next, the new Section 6WN, demand for provisional payment. Please refer to page 0034 of the markup copy. This new provision stipulates that if a basketball betting conductor has not made a provisional payment in full, the collector may, by a written notice given to the conductor, demand payment of the unpaid amount, and the notice must specify the date by which the payment must be made, and if the conductor fails to make payment in accordance with notice, the government will recover the said payment as a civil debt. This is based on Section 60 regarding betting on football matches. Please continue. New 6WO, please refer to the markup copy 003, page 0034 and page 0035. Assessment of net stake receipts. At the end of the charging period, the collector must assess the amount of the net stake receipt derived from the conduct of authorized betting on football matches by a basketball betting conductor for that charging period, and a notice must be issued to the collector. This is based on the current Section 6P in relation to the assessment of net stake receipt on betting on football matches. Please continue. 6WP now. Please refer to page 0036 of the markup copy. 6WP, additional assessment of net stake receipt. This applies if Despite having given a notice of assessment to a baseball betting conductor in relation to a charging period, the collector, if the collector reasonably believes the amount of the net stake receipt derived from the conduct of the betting on football matches exceeds the amount of the net received as specified in the notice, then it can issue an additional assessment for the amount not paid, and also can recover from the collector if this is not paid. 6WQ, please refer to page 36 and 37 of the markup copy. 6WQ, appeal against assessment and holding over of basketball betting duties. It stipulates that a basketball betting conductor that is dissatisfied with an assessment or an additional assessment, he may lodge an appeal within a month to the district court. It's based on the current 6S, and that is the basketball betting conductor who is dissatisfied in a similar way can also lodge an appeal. Please continue. 6WR, provisions relating to holding over. It would apply if, please refer to page 38 and 39 of our copy. If a basketball betting conductor is required by a notice of assessment or notice of additional assessment to pay a date and also has launched an appeal, and the collector has ordered that certain amount can be held over pending the final determination of an appeal. And after the ruling is made by the court, how the payment can be made to the collector is based on the current Section 6P regarding football betting. Next, 6WS, a new provision, a new section, surcharges. Please refer to page 39 and page 40 of the markup copy. Surcharges. If a basketball betting conductor fails to pay the amount by a certain date, then a 5% surcharge can be imposed by the collector. If it's not paid at the end of 6 months after the period of payment is exceeded, then he can also introduce a further surcharge not exceeding 10% of the total. Next, please continue. 6WT, please refer to page 40 and page 41 of the markup copy. A new section 6WT, basketball betting conductors may bet for hedging purpose. If certain conditions are met, a basketball betting conductor may place a bet for hedging purposes, but he must comply with the policy promulgated by the collector. It's based on 6Us and Section 6Us and 6T for football betting. Please continue. New 6WU, Section WU. Please look at page 0042 of the markup copy. A new section, 6WU, hedging policies of basketball betting conductors. A basketball betting conductor may submit to the collector for approval of policy on hedging. This is based on Section 6P with regard to the hedging policy for football betting conductors. Please continue. 6WV. Please refer to page 43 of the markup copy. This is about restrictions relating to basketball betting tickets. In the amended provision is based on 6Q on football betting tickets, and also 6Z concerning lottery tickets. Please continue.
We have completed Clause 15. Ms. Carmen Khan. Please, thank you. Apart from making reference to football betting, because as you've mentioned, you draft the provisions on basketball betting based on football betting. Can you further elaborate on the hedging policies? Under what circumstances would you approve of the hedging policy submitted by the Jockey Club? Seems that this is a policy question. Mr. Leung. Thank you for the question, Deputy Commissioner. The conductor of football and basketball betting likely use fixed odds bets to conduct their betting is sometimes likely that the conductor may lose money, so they may devise some risk management tools, which is the hedging policy in question. Under this clause, we allow the conductor to, based on the bets that they receive, place bets on matches outside Hong Kong. This is a hedging tool for the Jockey Club so that they can minimize or control the risk that they face. Chairman, I understand this. So the goal of this hedging policy is for risk management, but not speculation. Because speculation and risk management are two very different things and is not reflected in the provisions. The administration should only approve a policy when the conductor places bets to hedge against the risk instead of to speculate. We ask the conductor to submit a hedging policy to the administration for approval. When we scrutinize the policy, we will look into the factors that they have considered and the procedures that they propose to put in place. As mentioned, we will not allow the conductor to gamble by leveraging on their hedging policy. The bets placed by the conductor should only be for hedging purposes only. We will scrutinize the proposal submitted by the conductor. Understood? So under 6WT, the conductor will have to submit the hedging policies to the administration for scrutiny and the criteria set out there. Mr. Chan Shih-hong. Thank you, Chairman. On basketball gambling and betting, according to different statistics and survey, illegal online betting is prevalent. On 6WV, restrictions relating to basketball betting tickets. Same goes for football betting tickets. No one should be able to sell tickets illegally. Selling tickets on mobile phones or mobile applications is being restricted. If an illegal operator sell betting tickets that are not printed online, what happens? It says that a person must not make, print, issue, sell, or offer to sell a basketball betting tickets. So is digital betting tickets or coins regulated under 6WV? Who will take the question? Thank you, Chairman. Mr. Yim. The member asked about digital or virtual betting tickets issued by illegal operators. Well, as long as the operators accept bets, they are operating illegal betting activities and is already illegal under the existing ordinance, regardless of whether they accept bets online or offline. So as long as an operator or a company through various actions accept bets online or offline or in the form of coins, they will commit an offense under the betting duty ordinance. I just want to make sure that we have plugged all the loopholes. Criminals have a diverse tactics to accept bets illegally. I just want to make sure that we have covered all the bases. Thank you. Mr. Wong? Thank you. On 6WV, making, printing, issuing, selling, or offering basketball betting tickets illegally will be prohibited. Even if the operators sell virtual tickets, they will still commit an offense under 6WV. Even if you may not be printing betting tickets online, still they're issuing, and they will be prosecuted. Ms. Carmen Khan. Thank you. The legal advisor asked about the offenses under 6WV, and the administration have made a response on the criminal elements of the offenses set out in 6WV. I wonder if there is any precedence on football betting tickets and how it operates, in the sense that the defendants will have to bear the persuasive burden or evidential burden. We've made reference to the relevant provisions on football betting. Jockey Club is the conductor of football betting, and it is a very cooperative taxpayer. So upon passage of the football betting legislation, the Jockey Club has not committed any offense. That's why we have not taken any prosecution action. This clause regulates anyone, a person, not just the Jockey Club. I don't think that only the conductor is regulated under 6WV. It says that anyone who make, print, issue, sell, or offer basketball betting ticket, they will commit an offense. So my question is whether you have taken any enforcement action in this area. I know that the administration have replied to the legal advisor, and I believe that the legal advisor is satisfied with the response. I wonder if we have had any bogus or false betting tickets issued. Thank you. There's no precedent, but this is a serious issue. We will double check our records after the meeting to make sure that it has actually never happened. So no one has printed, issued, or betting tickets illegally. Well, the reason why I ask this is because this clause does not only regulate the conductor, but any person who make, print, issue, sell, or offer basketball betting tickets illegally. The administration just now said that they will submit a written response after double checking their records. On horse racing, on football betting, I believe that you have taken enforcement action before. I'm worried about the effectiveness of it. You said that you have caught some 300 odd illegal betting operators online. I just want to see if there is any enforcement action taken regarding making football or horse racing betting tickets before. Ms. Mack. Thank you. When we take enforcement action or initiate prosecution, we may invoke this particular provisions or other legislations. The law enforcement agencies have asked some 300 odd illegal operators to remove their illegal betting websites. We have prosecuted illegal bettors. As to whether we should invoke this particular provision or other provisions and legislations regarding this situation, I will supplement after the meeting. Even if we do not invoke this piece of provisions to initiate prosecution, we still need to keep this provision. We need to have different clauses and provisions parts in the ordinance to make it comprehensive. We think that is necessary for us to provide for such a restrictions to prohibit anyone from committing the laws or committing the offense. What I was saying is that I think that it's necessary for us to have such a restriction. We now impose a persuasive burden on the defendant. But in the Chinese version, the Chinese translation of persuasive burden is not provided for. Does the DOJ have anything to add on paragraph 14 of the administration's reply? Legal burden means the same as persuasive burden in English. We have already translated the letter into Chinese. In the fifth line, it says that imposing a persuasive burden on the defendant strikes an appropriate balance, so on and so forth. The administration said that the offense is a regulatory one. And is different from other offenses where defendant have to provide whether they have any reasonable excuse. Because this is an active behavior, that's why we impose a persuasive burden on the defendant. Mr. Chairman Kwong. Thank you, Chairman. I have one question regarding 6WV on the mode of placing bets. It seems that placing bets at betting stations will also be covered apart from placing bets on websites and mobile application. So physical place bettings will also be covered. Am I right? Mr. Yim? We never said that the mode of placing bets is limited to those placed on the mobile applications, websites, or physical branches. Upon the passage of the bill, the conductor will submit a proposal on basketball betting, and we will only issue a license after scrutinizing that proposal. As to the mode of placing bets, is not been provided for in the paper that we submit.
到啦。
Please continue. We're now on clause 16. Please refer to page 4 of the markup copy and page 45. 6X to be amended. And this is about the requirement to ask the Jockey Club to display the notices on any website and mobile applications which the company used to accept bets. Next, 6ZA, we want to expand the coverage of the term license so as to include basketball betting. Clause 17, please refer to page 46 of the markup copy. It amends the existing section 6ZA, and in the interpretation of license, we include a reference to 6WH to cover the license to conduct basketball betting. Next, clause 18, please refer to page 47 of the markup copy. Clause 18 amends the existing 6ZF concerning revocation of licenses, and it would be the scope would be extended to cover license for conducting football betting. Clause 19 amends section 6ZO. Members may refer to page 48 and page 49 of the markup copy. 6ZO is about powers of collector to correct errors and refund overpaid duty. The conductor has the right to ask for a refund or to correct errors. Again, the conductor for football betting can do the same like a football betting conductor. Next, clause 20, please refer to page 50 and to page 59 of the markup copy. This is only in relation to the Chinese version, so there's no similar amendments in the English version. This is also about the term Hong Kong SAR to substitute for the government in relation cap 1 of the Interpretation General Clauses Ordinance to assist consistency. Next, part 3. Amendment to betting duties regulations, that is Cap 108 sublect A. Please refer to 0060 to 0064 of the Chinese version. For the English version, page 50 to page 54, the markup copy. First, it amends the Section 3, capital A, submission of returns in respect of betting on horse races, and the guarantee period, the related provisions are repealed, and other textual amendments to maintain consistency with the Section 23. 3AA stipulates a horse race betting conductor must, within 3 months after the end of each charging period, submit to the collector a return in a specified form, set out the amounts of the net stake received derived from the conduct of authorized betting during that charging period. And for subsection 3, it's about a guarantee period which is now obsolete and will be repealed. Next, clause 22, please refer to page 62 to 63. For the English version, page 52 to page 53. It amends section 6.3 capital A, submission of returns in respect of betting on football matches. It's a textual amendment to assist consistency. There's no change to the substantive meaning. Please continue. Next, clause 23, please refer to the Chinese version of markup copy 00363 at page 0064, and for English version 0053 and 0054, it amends the Regulation 3A, and there will be a new with Regulation 3A or as amended for submission of receipt of betting of football returns. Page 4, some amendments to the specification of notices. Please refer to 65 or page 55 of the English version. Specification of public offices, there will be some consequential amendments so that the collector of the stamp duties may delegate certain functions to other public offices to enforce relevant provisions of the betting duty ordinance and related regulations. So that's all the clauses in the bill. Any questions? May I ask the legal advisor to confirm that the drafting of the English version is in order? We have just looked at the Chinese version. I have examined the English version and I did not detect any inconsistency. So we have completed the cross examination of the bill. Members who wish to move amendments to the bill may do so before 5 p.m. on the 1st of August. You should submit your amendments to the secretary, to the secretariat, but the Bills Committee sees no need to move any amendment. We have completed cross examination, but there will be a further paper to be given by the administration. When it's received, it will be sent to members. We have completed the scrutiny. It seems that we don't need to have a third meeting. In due course, we will follow up with the administration on the date to resume the second reading of the bill, and then a notice will be issued to members to inform you of the date. Any other business for members? If not, then the meeting's adjourned. Thank you for your attendance, members.